All right, thank you everybody for attending today. We are going to give you a brief overview of what happened in court this morning, and we're going to put it in plain English. And we thank everybody for bearing with us. I'm attorney Gloria Allred. I'd like to introduce my partner, Nathan Goldberg, and also my partner, John West. We all appeared remotely in Department N of the LA County Superior Court this morning for a status conference in reference to our case of Huth versus Bill Cosby, which has been stayed for some time. We've been awaiting the decision of the Pennsylvania Supreme Court, and the court did rule recently to vacate the judgment of conviction of Bill Cosby on 3 felony convictions for aggravated indecent assault on the basis that a prior district attorney, Bruce Castor, had promised to not prosecute Mr. Cosby, even though a lower court had found that there was no such promise. The Pennsylvania Supreme Court had the last word and vacated the judgment. Nathan, in just a few moments, will deal with what happens next, according to the defense, in that matter in Pennsylvania. I will deal with the issues of taking Mr. Cosby's deposition in our civil lawsuit here in California, and also the issue of so-called look back and the defense indication that they want to challenge that recently passed and now in effect new law in California. John West will deal with all other issues, including trial dates and other upcoming issues. So let me just start with the writ of mandate issue with Nathan, and
Sure.
Then I will have something more to say about the other issues, and John will also have important points to make. So go ahead, please, Nathan.
So in the Pennsylvania case, the prosecutor has until September the 28th to file a petition for a writ of certiorari with the U.S. Supreme Court.
Yeah.
Whether they will do so or not, we have no idea. It's completely speculative, but that is the last date by which they could file such a petition. The judge stayed the matter as to Mr. Cosby in terms of discovery until that date because he didn't want to rule on that or open up the door for Mr. Cosby's deposition until we saw whether the prosecutor would seek a writ of certiorari. Until their time is lapsed to do so, the decision is not completely final, decision by the Supreme Court of Pennsylvania. So that's where that stands.
Thank you very much. And that leads me to the next issue. And by the way, I think I misspoke and said it was writ of mandate. I meant a writ of certiorari. So to this United States Supreme Court. Having said that, it does lead me to the fact that the defense has indicated that when Mr. Cosby has to take his deposition in our case, that he intends to invoke his Fifth Amendment privilege against self-incrimination. Just to back up a little bit, we did take Mr. Cosby's deposition in the civil case some years ago, and that is under seal, so I cannot discuss what Mr. Cosby answered in that deposition and what he failed to answer. I will say, however, that based on what he answered or failed to answer in that first deposition of Mr. Cosby in this case, we made a motion to compel him to appear for a second deposition. Ordinarily in California, It's a 1-day deposition, 7 hours. So we had to make a motion to compel him to appear for a second deposition. We did make that motion. That Mr. Cosby's defense team at that time objected to Mr. Cosby having to appear for a second deposition. However, we argued that he should be compelled to appear, and the court agreed with us and compelled him to appear for a second deposition. However, since at that time, Mr. Cosby was being prosecuted in Pennsylvania, the court stayed the taking of his second deposition until such time as the Pennsylvania criminal prosecution of Mr. Cosby concluded. We believe that it has concluded at this point, or if it hasn't concluded by the time that the Pennsylvania prosecutor fails to file the writ, that we should then be in a position to take Mr. Cosby's deposition. In reference to his assertion of his Fifth Amendment privilege against self-incrimination, we would be arguing that Mr. Cosby is not in jeopardy of any criminal prosecution. We don't know of any at this time, and therefore he should not be able to assert his Fifth Amendment privilege against self-incrimination, because there would be no prosecution pending. The defense has taken different positions. His spokesperson has indicated that the Los Angeles Police Department has told them, that is the defense team, that their investigation of Mr. Cosby is closed. And if it is closed and there is no prosecution, then he is not in jeopardy of being prosecuted in Los Angeles. And there is no other investigation of Mr. Cosby open in Los Angeles of which we are aware. So that brings up that essentially we think that unless there is a writ by the Pennsylvania prosecutor, that what we should do is we should just be able to go ahead with the taking of Mr. Cosby's deposition. And that's what we would like to do. And we will be arguing that at an upcoming hearing. And we'll also talk then at that hearing about the issue of taking Mr. Cosby's deposition, and also how the issue of his invoking the Fifth should be addressed by the court, if that is what he intends to do. Finally, I just want to say that in reference to the issue raised by the defense in their joint letter report to the court today of their plan to challenge the constitutionality of what we call the look back provision in California, that is a major issue. They are saying essentially that they know that the new law does apply to the plaintiff, our clients in this case. In other words, that she is covered and that it has timely filed her case, and that there's no issue about that in reference to her if the new law is constitutional. However, they say they plan to challenge the constitutionality of the new law if the new law was deemed to be or decided by a court, and ultimately that would have to be a decision that would go most likely all the way up to the Supreme Court of California, to be unconstitutional. That is going to inflict significant harm potentially on many victims of child sexual abuse in California. Because in plain English, what the new law does is it opens up access to the courts for many victims of child sexual abuse who may have been victimized in prior years, many years ago, potentially, but for many reasons, never came forward, never exercised their option to file a lawsuit at that time, but would still like to be able to file a lawsuit and have access to justice in a civil lawsuit in California. And if the defense, Bill Cosby's defense, is successful in having that new law, which provides access to justice to so many victims of child sexual abuse or alleged victims of child sexual abuse, if that is declared unconstitutional, it is going to be a significant barrier to those who allege they are victims to being able to have access to justice in the courts against those that they believe and assert are sexual predators and who have significantly harmed them. So we will be addressing that issue later on in this case. It was not something we could address today, but it definitely is going to be addressed in the future. With that, I'm going to turn it over to my partner, John West, to talk about what's upcoming in terms of trial dates and other dates coming up. Go ahead, John.
Thank you, Gloria. The case has been set for trial on April 18th of 2022. And the court, recognizing the number of issues that need to be addressed before the case can, really proceed to trial, has asked us to come back to court on September 30th with an outline of what we believe the issues are, how we believe they should be addressed, and when they believe they should be addressed. And so we will be conferring with Mr. Cosby's attorneys in an effort to reach an agreement on those issues before we go back to court on September 30th.
Anything further, John?
There is an open question as to what's called the 5-year rule. California requires that cases be brought to trial within 5 years of filing unless it's impractical to do that. And in this case, because of the many, many delays occasioned by Mr. Cosby's criminal prosecution, we have been either completely unable or substantially unable to go through the kinds of discovery processes that we need to get this case to trial. And so there is a question about how much time actually remains on that 5-year rule because of the impracticability of taking the case to trial. The judge has proposed a very equitable solution for the parties to agree on the trial in April of 22, not violating that rule. And that's also under consideration.
Because our case has been ongoing for 6.5 years.
Right.
If anyone who is tuned into this press conference would like to ask a question, please type in your question now, and we will open it up for questions. While we are waiting to see if there are any questions, Nathan, is there anything that you would like to add, or John, you would like to add or correct to what has been said?
I would just like to add the fact that from our perspective, the court had already ruled that Mr. Cosby has to sit for another deposition. We regard any Fifth Amendment privilege argument as frivolous. We don't think it makes any sense in light of the fact that nobody's prosecuting him at the moment, and we're not aware of anybody prosecuting him. We just don't see that as a viable argument. As far as the constitutionality is concerned, argument, this look back window that was passed in California, there's a lot of other states that have had similar look back windows, such as New York. I think in New York, the look back window literally expired today, but it was in effect for years. And we believe that it was passed by the legislature. We think it is completely constitutional. And as Gloria said, it would be a major setback for victims of child sexual abuse if a court were to rule that it is not that look back window is not constitutional. It's equitable, it's fair, it's in keeping with protecting victims, especially child victims. So we think it's very important that the court rule that it is completely constitutional and applicable to Ms. Huth in this case.
I would also add that even if I'll say, God forbid, a court should find that this extremely important law, which so many people worked to have signed into law and become law, even if it were to be declared unconstitutional, which we think is unlikely, but always possible in the courts, that we still feel that we should be able to proceed with our case because we feel, without kind of taking a deep dive into the weeds of this case, it's still our position that Ms. Huth has timely filed her case.
In fact, Mr. Cosby's previously challenged the timeliness of the filing, and we've defeated his efforts. He tried to take them into the Court of Appeal through his prior counsel. We defeated that. He tried to take it to the California Supreme Court, and we defeated that with regard to the statute in existence before the new look back provision. So we're comfortable that under either statute, Ms. Huth's claims are timely, and we're also confident that the constitutional argument will fail. This law was not passed with Mr. Cosby in mind. It was passed for the benefit of everyone in this state. And the legislature did its job carefully when it enacted it.
And the governor signed it, and we give credit both to the legislature and the governor, and also all victims of child sexual abuse and their attorneys who lobbied for, sacrificed for, and worked so hard to get this law passed. Okay, let me take some questions very quickly. There's one that says, it sounds like there was no actual decision today. Is that correct? John, you want to tackle that?
Sure. It would have been difficult to decide anything today. So the court set up a framework for these issues to be decided down the road.
Right. So we have further dates when we'll be returning, and then those issues will be decided for the reasons which we have discussed. I don't think there are any other questions. Unless someone has something else to add, Nathan or John, then we are going to conclude this press conference. We thank everybody for attending, and we look forward to continuing the battle for our very brave client and against the attorneys that Mr. Cosby has, new attorneys. He's had many different law firms, different attorneys. I've lost count of how many have been representing him. And then suddenly they're no longer representing him. And then they're new attorneys. And then they're representing him. And then they're no longer representing him. We cannot know why Mr. Cosby has had so many different law firms, so many different attorneys. We don't know why. That is not for us to know. But so he'll have new attorneys now, and we're looking forward to fighting the good fight against them and what appears to us to be Mr. Cosby's efforts to delay justice for our client. And we're going to push forward and push hard because we want to get this case tried, and we want to fight for justice for our client. Thank you so much, everybody, for attending. And we'll give you an update when we have one. Oh, the dates again. I'm sorry, the dates again. John, you want to repeat the date? Someone's
Sure.
asking.
We're going back to court on September 30th to present, each side to present their ideas about how the case should go forward, with a trial date of April 18th, 2022 in mind. And the court will, when we go back on September 30th, probably set a time frame to resolve the various issues that Gloria discussed in terms of challenging the look back and how we're going to address any assertion of the Fifth Amendment.
Exactly. Nathan, did you want to add anything?
No, that's basically
All
it. Okay.
Oh, okay. Wait, and there's another question, which is, can we clarify that the stay was lifted?
The stay was lifted as to all discovery, except with regard to Mr. Cosby, the stay remains in effect until September 30th, pending the decision by the district attorney as to whether or not they will seek a writ of certiorari in the US Supreme Court.
So Nathan, just to clarify what you just said, when you say the stay was lifted except as to Mr. Cosby, are you talking about the stay was lifted as to the taking of Mr. Cosby's deposition?
No, it means that all discovery can proceed with the exception of Mr. Cosby's second deposition.
Yes, that's what I'm saying.
Yes.
Okay, thank you.
Okay.
I see no further questions. Those were all good questions. And everybody, thank you so much for attending. If you, we will be putting a copy of this press conference up. If anybody needs a copy of it, you can feel free to broadcast a copy of it. And we thanks again for attending. We are now concluding this press conference.